This is Raluca Vasilescu, who is the co-founder of one of the probably the most important patent attorneys firm in Romania, Oproiu, Cabinet Oproiu. And I think she will address actually some of the questions that were asked, particularly about this issue of transfer between employees to the institutions and the specific Romanian legislation.
Bună ziua, doamnelor și domnilor! Mă bucur să mă aflu astăzi aici. Este prima oară când mă aflu în acest oraș și în această universitate. Sper să pot oferi o viziune complementară cu ceea ce au spus colegii mei. My presentation of today is complementary to what the other speakers have said. And it's more focused on the provisions of Romanian legislation. I'm a Romanian patent attorney since 1999, working in Cabinet Oproiu law firm, dealing with filing of patents in Romania and abroad, prosecution of patents, and enforcement of patents. That means that those difficult cases where the patent is infringed and one has to go to the court. Therefore, my presentation referred to the experience we have with Romanian applicants and inventors. I shall not refer to the experience we have with foreign ones, because I think it's more useful to you, the experience we have with Romanian applicants and inventors. With the explanation that the majority of our cases of Romanian applicants and inventors do not refer to universities. We have little experience with universities, but we have a lot of experience with companies. A very short introduction. Why patenting? We know that patent is an exclusive right. It has been also said by my colleagues. It's an important asset that may produce benefits to the proprietor. The word may is not by coincidence there, because sometimes the patent produces benefits, other times no. My colleagues all have said that. My point of view is the point of view of an attorney. The duty of the attorney is to serve the client. In this case, the duty of the attorney is to ensure the best chances to obtain the patent. The attorney does not know about the commercial value of the patent, so I will not refer to what has already been said. For us, all patent applications have the same value until the moment when the client says, stop, we don't want to proceed anymore, we don't want to go any further with this patent, we want to abandon it. So for us, all the patents have equal value. Patent protection in Romania can be granted in two ways. The first way is the national route, when the inventor is also named assignee, file the application directly with OSIM, and the result is a national patent. The other route is when patent comes from another jurisdiction. For example, when an European patent is filed with the European Patent Office in Munich, the result is a bundle of patents. The correct term is a bundle of European patents that are further validated in this jurisdiction of interest. Or, of course, another alternative way is the PCT route. That means the patent applications filed with the International Bureau of the World Intellectual Property that are later on entering a national or a regional stage. I think that this matter has been briefly touched by Mr. Capani. We have three legal requirements in Romania. These legal requirements are almost the same in the major jurisdictions all over the world. That means the invention must be new, the invention must involve an inventive step, and it must be susceptible of industrial application. Novelty and an inventive step, very important requirements, are analyzed against prior art. Now, before discussing prior art, I will discuss what is the relevant date. I wrote here relevant date. The relevant date can be either the date of filing, that means when the application is directly filed with the Industrial Property Office, in this case OSI if we think of Romania, or the priority date. The priority date is when you when you file the first application. This is T0, and you file application number 1. That gives you a term of 12 months maximum until you can file application number 2 in another country, or you can file a PCT application within international bureau. So the relevant date can be date of filing. If you have only a filing date, for example, for A1 is in country 1, so you have the filing date, or you have the priority date. For A2, the priority date is this one, and the filing date is this one for A2. Priority date, filing date. Now, what is prior art? All knowledge that has been made available to the public by means of written or oral description by use, or in any other way before the relevant date. What is public? Public includes all persons that do not have a confidentiality agreement with the applicant or the inventor. Therefore, these persons from the public are free to disclose the application. When you have a confidentiality agreement, for example, with the TTO, this does not mean that TTO is a member of the public, because they have a confidentiality agreement. So we have an element of the prior art that is the public, and the other element that is the description, the written or oral description. What does prior art include? Any other granted patents anywhere in the world, the so-called patent literature. Other patent applications. So the first one refers to granted patents. The second one refers to patent applications filed anywhere in the world, provided that their filing date is prior to the relevant date, provided that is prior to their filing their relevant date, and the second condition is that they were published or after that date. That means that the patent application that is not published, that is abandoned before publication, shall not be part of the prior art. Other examples of prior art: books, articles in professional journals, lectures, including, for example, this lecture, including publication on the internet, oral disclosure of the invention if made in public. It is considered prior art. Use of the invention in any way before the patent application filing date or priority date. Use of the invention, it's not important who used the invention, if it was used by the applicant or inventor himself or by other party. Prior art is, the term prior art is linked to the word disclosure. It is considered that the invention was disclosed in prior art. There are some exceptions to the disclosure. When court, before 6 months before this time, and it was from an abuse as far as the applicant is concerned. That means that the applicant did not disclose the invention himself. Someone heard him and then disclosed the application. Or another exception is when the invention was disclosed in an international exhibition recognized according to the Paris Convention regarding the international exhibition. These exhibitions are recognized to provide a certificate of exhibition. That means that if you disclose the invention here in an international, such an international exhibition, you will get a certificate saying that you disclose this information. And with this certificate, you go here and file your application. And in this case, the disclosure is not prejudicial to your patent application. Abuse is also considered when the third party steals an invention, either from the applicant or from the inventor, be it partially, that means only part of the invention, or in whole. Major phases of the patenting process. I will not go through all of them. I would simply tell you from the point of view, again, of the attorney, helping the applicant to go through the stages. The first is the idea, getting a technical solution. The second step, very important, is the search. The search in respect to prior art. Mr. Katana told us that in Switzerland it's possible to go to the patent office and have a search in that day. In our country, it is possible. It's not a one-day search, but you have to submit a request in writing with the patent office, and they will make a search for you. It's not on one day. They will deliver it in 7 days, in 10 days, or in 2 weeks, but you can get a complete search report by the patent office prior to the filing. Based on the search, it's the drafting of the application. Who drafts the application? The inventor and the attorney. Filing the application with the patent office of the country of origin, requesting an official search report after filing the application. It will not be identical with the first search report, because from the first moment in point 2 and until the moment after the application, you have now the invention. It's a little bit different. So the search report at point 5 will not be identical with the one drafted at point 2. When you have the search report, and you usually have it here about 10 months, based on the results of the search report, you can decide if to go further. That means if from the legal point of view you have good chances to obtain a good patent application, then you go to the next step. That means filing in another country or filing a national application. If the search report is really very bad and shows that there are major obstacles to obtaining your patent application, it may be better to abandon it. This is why in point 6 I put decision as to whether to file in other jurisdictions. Supposing that the search report is good and there are money in the pockets, now go to step 2, file either conventional patent application in another country or a PCT application, and then prosecuting each of those patent applications in the countries of interest. If everything goes fine, we have the grant of the patent, the payment for the letter patent and accumulated annuities. Point then, it's the nationalization of the patent when applicable, for example, the case of the European patent in the countries of interest, and then, very important, paying renewal fees for the patent each year until the expiry of 20 years from the filing date. Of course, provided that the patent is still of interest. Now, I would like to tell you some tools that are very interesting for you as inventors and possible applicants. Tools that give you time to think. One of them was already touched, the convention priority. Convention priority is when you want to go to another country. And you have the time here between roughly 2 months to decide whether to go or not to go. The other very interesting tool is the intended priority. When you have, and now we're talking only about Romanian legislation. So you have a NOSIM, you have a T0, you have an application 1 that you drafted very quickly and you're not very sure of it, that it was correctly drafted. You have 12 months to draft, say A11. 2 months to draft either a new patent application that includes A1 but a little bit more, say, refined, but it has to include this. Or you simply resubmit A1. This is called internal priority. When you use internal priority, this one will be abandoned, and you will prosecute this one. But the prior art will start here, because this is the final date. What do you gain here? You gain more time to think, because the convention priority here will start here and not here. And you have more time to refine your application, because when you file it here, if you do it on a rush basis, something will probably miss. So you have the time to refine it. On the condition that this includes this. So you have this one, say, is A1, and the other one is just a little bit, you have to do just a little bit more, but not too much. Another tool is the possibility to file the claims between 2 months from the date of deposit. You file the application here only with the description. I presume that you are familiarized with the content of an application. You have the description and you have the claims. These are the two basic elements of an application and the two mandatory elements of the application. Other elements of the application can be drawings. It's not mandatory. Some inventions do have, others don't, or tables. Also not mandatory. But the first ones, description and claim, the first ones are mandatory. Now, for obtaining the filing date, that is this one, you need only the description. This is minimum filing requirement. You can file the claims in 2 months. It is possible. The disadvantage is that when you draft the claims, you have to stick with the text of the description as filed. You cannot broaden. If you forgot something at the moment of filing the description, you cannot add that later on. This is the disadvantage. Now, some pitfalls for the applicants and inventors. Pre-filing search is not made at all, or is made poorly. If pre-filing is not made at all, we reinvent the wheel. So we waste time with reinventing the wheel. Other pitfall, the inventive activity is not covered by the obligation of confidentiality or is breached. What happens in such cases? Disclosure of the invention. And disclosure, we just learned, is giving documents to the prior art, and in this case, novelty or inventive step criteria cannot be met at the moment of examining the patent application. Other pitfall, very important and very big. The inventor or applicant discloses himself the application of prior to the filing, usually by writing articles in professional journals. My colleagues have also pointed out this very important requirement not to write. First file and then write. The application is drafted poorly. If the application is drafted poorly, it may never proceed to grant. Other pitfall. Deadlines are not taken care of. Patenting is a very complex and long process with a lot of deadlines. Some of the deadlines refer to payment of some fees. Other deadlines refer to some legal requirements to be met. Documents, responses to official action. There are a lot of deadlines. If you miss one of the deadlines, in the happiest case, you can still prosecute your applications if you pay some extra fees and you provide for an argumentation. But in other cases, you cannot. The application is deemed to be withdrawn. Other pitfall, other problem. Communication between inventor and applicant stops at the moment of filing. In some cases, for whatever reasons, the inventor and the applicants do not communicate any longer after the applications are filed. Usually the inventor goes to another company and there's no other communication. If there's no communication with the inventor, it's very difficult to prosecute the application. Other pitfall. The applicant makes confusion between a granted patent and an application. An application is an application, may proceed to grant or no. When mentioning the patents in a conversation or in offers for potential clients, some of the companies make confusion and say that they own that many patents. And in many cases it's wrong. They are not granted patents, they are only applications. And last but not least, applicant or inventor fails to communicate properly with the attorney. What does it mean? Fails to communicate promptly with the attorney refers to two situations. Situation when the application is examined and the attorney needs continuous and prompt feedback from the applicant and the inventor. And secondly, sometimes the applicant forgets to inform the attorney that they are no longer interested in the application. As I said at the beginning, for us attorneys, all applications are important. All patent applications have equal value. We don't know what is the commercial value for you until you say to us, please abandon the application. If you don't say to us, please abandon the application, we incur costs. For example, for transmitting you an official action, commenting on an official action, that means working on it. And we don't know that you're no longer interested in that patent application. Now we come to employee inventions. I will make a summary of the legal provisions. Before entering into the matter, I would like to tell you that the law provides for some situations, but the parties can conclude agreements with other provisions. So the law provides the default provisions in case there are no other agreements between the parties. We have two situations in paragraph 1 and paragraph 2. I made this drawing because when we go with the other slides, we have to go back to this. So you have the first situation is when the inventor, employee, is within the employer, and it's only between, the problem is only at the level of the employer. So there's one situation when the right belongs to the employer, in case the inventions are made under a contract of employment which explicitly provides an inventive mission for the employee corresponding to his duties. Put in other words, the employee was employed to invent. This is his job, to invent. In this case, the right belongs to the employer. The other situation is when the right belongs to the employee, in case he does the invention, makes the invention in the course of his duties, but these are not provided in the contract. He was not employed to invent. He was employed to do other things, but he invents. Or in any other situations that are not covered by A or B. So this is the first situation. The other situation is when the invention is the result of a research contract, which I understand it's the case when the university is asked by a company. Now, in this case, Romanian law provides that unless otherwise provided between the parties, the right to the patent shall belong to the employer who commissioned the research. That means that it is possible to conclude any other type of agreement, but in case of no other type of agreement, the right belongs to the employer who commissioned the research. Now let's see what are the obligations of the parties. If the invention is made in the course of his employment, the employee has the obligation to inform in writing the employer about the creation of the invention. He has to write a letter to the employer stating the subject matter, the field, the conditions in which the invention was created, and what is his feeling in respect to which category is applicable. Was it made because of the contract and because he has a duty to invent, or is it in the other situation? When the employer has the right to the invention, the letter of information must be accompanied by the description of the invention. When the right belongs to the employer, the inventor, that means here and here, the inventor has to be paid additionally with a negotiated remuneration specified in a contract, a separate or additional clause to the labor contract. That means an additional burden for the legal department of the company, but things have to be very clear from the beginning, which is the additional remuneration for the employee in order to make the invention. The other obligation is that it is necessary to file the patent application with Romanian Patent Office within 60 days from the date when the employer was informed about the invention. Very important, in case the employer does not exercise its right to file the application, then the right of access to the employee. Unless otherwise agreed between the parties. The parties in a contract can agree in a different manner. Now, what happens when the right of the invention belongs to the employee? He has the obligation to make the first offer for a license or assignment to his employee. And this has to be also in writing, and the employer has 3 months to respond if he is interested or not. If the employer is not interested or does not respond in any way, then that means the employee, can exploit his invention with any other third party. In all cases, the inventor and the employer have the obligation to inform each other in writing on the creation and the stages of development of the invention. And, very important, have the obligation to refrain from disclosing the invention during the procedure up to publication of the patent application. Why? Because disclosure can be harmful for the novelty and inventive step of the application. Very important, the employee inventor shall benefit of the monetary compensation determined according to the economic or social effects resulting from the patent exploitation of the economic contribution of the invention. This is the wording of the law, is a little bit complex. The idea is that the employee has two kinds of monetary compensation. The one is the additional remuneration, which is like a salary or something similar. And secondly is a monetary compensation that depends on how valuable is the invention, depends on what result it produces to the company. Both elements have to be included in the contract. I thought important to mention a specific provision for Romanian inventors. According to the law, the inventions made by Romanian natural persons on the territory of Romania may not be patented abroad until a patent application has been filed with the Romanian Patent Office. That means that if you do your invention in Romania, you have to first file it in Romania. If you create your invention, for example, in Switzerland, there's no obligation to file it firstly with the Romanian Patent Office. So these two conditions have to be met simultaneously. On the other hand, I must tell you that the law does not provide for any sanction in case these conditions are not fulfilled. And I'm not aware of any case law what happened if they were not. But I'm obliged to tell you that these provisions are important and they should be respected. Now, we come to approaching the final, and I'm presenting you some figures under the heading optimizing cost, the point of view of the attorney. We know that patenting is expensive. We know that many people say that we attorneys charge too much. I don't know if it's true or not. The work is very, very difficult. The target is to optimize the costs in order to obtain best protection and as closest as possible to the original technical solution. Now, common errors. Avoid pre-filing search or doing it poorly. Poor drafting of the patent application. If you do not do search, the invention may already be in a state of art, so the money for filing and examining may be lost, partially or totally. If the patent application is drafted poorly, it can be rejected, or what is obtained can be a very small part from what was originally filed. Poor drafting of the application can lead to a weak patent, easy to be attacked. I've seen in infringement cases, usually in infringement, what happens is that when you sue a person or a company for infringement, that person usually attacks your patent, filing an invalidation claim, which is perfectly legal. Now, if your patent is weak, it can be cancelled. And if it's cancelled, not only that you will never win in an infringement lawsuit, but you can pay damages to the infringer, which is very good. And of course, defense of the patent is very, very, very cost intensive. Common errors in the filing stage, so after you file the application. Here. Deadlines lost. Now, if you lose a deadline, you may pay more or you may lose your application. Proceedings to follow are not chosen properly according to the actual need and interest of the applicant. For example, if you file in this country, but in reality, you should have filed in another one. Or you file, for example, EP patent application, but in reality, you are interested by a country that is not member of the European Patent Convention. Applicant loses contact with inventor, was already discussed. Poor or no response to office action. From the moment you file the application, when it enters the substantive examination, you will get a lot of letters from the examiner. It can be 1, 2, 3, 4, or many. Each letter has to be responded within some deadlines. If you don't, you can lose your application. So these are the results. When you obtain the patent in the grant phase, grant and post-grant phase, so you're very happy you have the granted patent. Now you have a deadlines in certain cases, for example, in the case of the European patent, to validate your patent in the countries of interest. If you don't lose these deadlines, you cannot validate anymore. You lose the possibility to have a patent in your countries of interest. If you have insufficient information about national procedures, you can pay more. In jurisdictions of interest. Now, solutions to common errors. Maintain a good and efficient communication between applicant, inventor, and attorney. This is the ideal case. Make budget estimates from the beginning and update them regularly. Always stop procedures when you are no longer interested in the patent application. And last but not least, select good attorneys. Example. Patent A, mechanical field. 34 pages, 17 claims in the mechanical field. Entering original phase of the EPO, roughly 4,000 euros. Prosecution of the EPO, 2 years, including the payment of the 5th and 6th annuity, roughly 3,000 euros. Why was that so? Because of a very difficult communication with the inventor. Now, if the communication is lost with an inventor, the attorney has to figure it out, how to respond to the official action. He can, a good attorney can always respond alone to an official action. But the person that better knows the technical solution is the invention. So the attorney can obtain a good patent, but it would be far away from the initial application. Validation in 12 member states, roughly 12,700 euros. So in this case, communication was very difficult. The applicant gave late instructions for validation, and it resulted in higher validation charges, including for translation. And we think that part of this cost could have been saved with a better communication with the applicant and with the inventor. Now, on the other hand, a patent B with more pages, 46 pages, plus 17 drawings, total of 63 pages, 41 claims. So this is larger patent than the other one, the same field. Entering regional phase of the European Patent Office, 5,200 euros. Prosecution, 6 months. Why 6 months? Because of a good communication. And because of the pre-filing search that resulted in a good drafting of the application. Validation in 24 member states, almost 28,000 euros, which is not very much, thinking that there are 24 member states. Excellent communication with the inventor from the drafting and with the applicant, which led to prosecution time shortened. And instruction for validation is given in the early stage. The deadline for validation is usually 3 months, which is sufficient to make translations and send instructions. So, patent B, although it was much bigger than patent 1, had costs optimized. Well, it's difficult to give a universal recipe for optimization, but I think that I gave you an example of how it can be. Romanian example. Romanian patent application, 43 pages, 9 claims in the internet. It's a method of doing something with 3 official actions. Now I gave the prices in Romanian currency. Official fees, almost a little bit more than 2,000 lei. Charges, filing and prosecution, 3,800. It's not much. Official fees for grant and accumulated nearly 2,000. Charges for grant and annuities, 500. Total, less than 2,000 euro. And finally, the conclusion, patenting is a very long process, and very difficult, and that communication between inventor, applicant, and attorney is essential. This communication ensures the optimization of the costs. Thank you very much.
Thank you very much. I would like maybe more questions, but not too many. My first question is about the, let's say, common practice in Romania, about, as you mentioned, your experiences with private entities, yes? Okay, so for private entities, which is, let's say, the common practice in Romania about the relationship between the company and the inventor in terms of, let's say, the percentage from, let's say, revenues or other kind of incentives given to the inventor by the company, let's say 0.5% of the profit of the company. I'm excluded from this discussion, let's say, a higher salary. Just
As I said before, there are two types of compensation. One is the additional salary, which is not, we're not talking there about additional salary, and the second one is that compensation that should be proportional to the economic revenue of the company.
yeah, but this is a very sensitive issue for me because a product which is sold in the market has more than the patent itself in the component of the product. And beyond of this, there are many other factors that contribute to the success of the product in the market. I mean, salespersons, marketing, everything which is directly with this effort of commercializing. So, therefore, which is the practice? So, have you seen examples in Romania of this second case to give incentives because of the benefits of the company by selling that product, which incorporates the patent?
Not so many. According to the law, the parties have to have a contract. The implementing regulations of the law establishes a minimum quantity of the compensation. I have the figures with me. I don't know them by heart. I have the figures with me and the articles. In the break, I can give you the figures. The idea is to negotiate and to conclude a contract. In the majority of cases, the initiative is of the inventor because he will be the beneficiary. So he has to discuss it with the employer. It's not possible to do this before creating the invention because nobody will know what will be the value. So at this stage, he can also only negotiate the additional salary. But this has to be at a later stage. The parties have to negotiate.
Yeah.
There are no clues about this. Only the minimum figure established by the implementing regulations has to be observed. And what is above this minimum figure has to be negotiated between parties.
I think I can answer
Yeah.
talking
Yeah, and afterwards.
You have another question, please. I think this is a question that everybody has, and this is, I was expecting this to come up. Well, first of all, there's an aspect that was mentioned, and there's a huge difference between universities and private sector when regarding exploitation of intellectual property. The universities exploit the intellectual property itself, whereas the companies exploit products they put on the market, and the two are completely different. The fact that there is a practice in the private sector has no bearing on what universities do because it's two different worlds. For example, Dr. Katana mentioned that it's common practice, and this is not just Lausanne, it's many universities that are active, that remunerate inventors as a percentage of the revenues generated by the university, not by the company, by the university. And this is a common practice. This, as far as I know, in the developed countries, does not exist in the private sector. I have not ever heard of any company compensating its employees proportional to revenues. This would be absolutely insane. It would destroy the companies because there are many patents, there are thousands of patents with tens of thousands of inventors. And if they each had a chunk, then the company would not exist anymore. This does not apply in a university because it's a completely different world. So that's the one thing to mention. The second thing to mention is specifically about Romania. Romania has this legislation which stipulates that there are these minimum percentage remunerations that are specified in the law 547 from 2008. Actually, it's government decision. And those apply to the private sector as well as it applies to everybody. For a university, it's not a problem, but for private sector, it's a huge problem, which is why there's strong lobbying going on for many years trying to change this law. But for the time being, we still have it. Now, this is not a problem for patent attorneys because patent attorneys do not intervene in the affairs between employers and employees. They deal with filing applications and protecting inventions, and what happens between an inventor and the employee is between them. So this is something that lawyers at these companies worry about. And from my interactions and discussions with lawyers that are involved in this kind of aspects, I'm not aware of Romanian companies truly, basically, correctly implementing this legislation. They are not aware of this situation because it's so strange. No other country that I know of has provisions that give employees in the law percentages of the revenues of the company. So this is something that is very weird, and I think a lot of companies are basically in denial. They are pretending it's not there, and they go on like this. And this is a kind of a train wreck kind of waiting to happen. If anybody of the companies that are represented here, I'm very curious to know if anybody of the people that are represented here from companies, they know of anybody actually applying this law, of actually giving their employees, inventors, the percentages that are written in the law from their revenues. I'm very skeptical that there's any company that does this. Now, so the answer to your question is the good practice, international good practice is no. Employees generally get a bonus. You know, you get 300 euros, you get 1,000 euros, you get a pay raise in your salary, but you never get royalties from your invention from your employer. This doesn't exist. On the other hand, in Romania, there is this strange legal situation, and it's very confusing, it's not clear. And so basically, the answer is, it's a good question, and I hope maybe if there is some private sector people that they can tell you what the practice is. But as far as I know, it's not consistent. It's not consistent. So, you want to...
Thank you. Very shortly, I've seen a couple of cases in private company, not the payment of royalties, as you said, but kind of down payments at certain stages when the new invention was made and mentioned to the employer, and if a committee of short team had taken the decision, yeah, it is very interesting, then the inventors got some money at this stage. And then if the prior art search was made and the results were positive, no prior art or relevant prior art, then a second payment in favor of the inventor, and then filing, and then different step until the launch date on the market, and then the inventors again got some money. That's what I've seen.
Yeah, maybe just to add something, indeed there is this use of a bonus when an inventor files a patent application, what contributes to filing, brings an invention in a company, and this is done usually at the time where this invention is disclosed and the patent is filed. And he gets, I remember a couple of tens of years ago at IBM, they had the policy of 3,000 Swiss francs for the first filing, and something like that in this order, but nothing on revenues. If I can take just one more minute, I do have a comment with respect to a very interesting presentation you made. The first one is I see that the Romanian law is really complex. If I'm looking closer to the university implications, it's really difficult. It will make it very difficult to implement this innovation culture and this easiness to file patent application, because there are a number of problems to be solved. So ownership, filing first in Romania. So I don't know if we may take some time to all think about what could be done. Many times we never filed a patent application in Switzerland. We never start with filing in Switzerland. Why? So for me, it makes, from a university point of view, it makes sense to file where there is a market and where there may be opportunities to enter into collaborations or into licensing with third parties. So why wouldn't it be possible to file in the US, for example, and keep only the US market for many IT companies? software-based or medical also, the market is big enough, and this is a real value that can be brought when you discuss with the investors or with other companies. I understand that in Romania this is not possible, but if we can think about, wouldn't it possible, you say, okay, we have to file first in Romania,
It's not
but in the same day,
Yeah.
in the same day, we file a patent application in Romania, and the same day we file a provisional patent application, whatever, or regular, in the US, is this okay with the law?
I think yes. Firstly, before responding to your comment, the idea to first file in Romania, that means this one here, is not such a bad idea, because filing an application with Romanian Patent Office is rather cheap, and you have a good search report at around 10 months after the application. Now, you can file it here, and at the same time file it with US Patent Office. And then depending on this search report,
You continue or not?
you continue or not. It is worth filing in Romania because it's cheaper. This is why. And the law does not provide sanctions for not doing this. This is why this is a matter to be analyzed, the pros and the cons. If one decides not to respect that provision to first file in Romania, but on the other hand, knowing that there is no sanction about it, it's something like a personal decision: shall I go or shall I stop? On the other hand, you can file this simultaneous patent applications or one day after, or whatever. It's not detrimental. The only problem is that if you file in Romania, you have to file in Romanian language. But on the other hand, because if you file the application directly, it has to be in Romanian. If you come with the convention priority, and you have here, for example, from Switzerland, you can file it directly in whatever other language and provide the translation later on. But when you file here, the first one has to be in Romanian.
Okay, it's a good point.
Professor, you had some more questions?
Yes. Yeah, but I can
This is for the camera.
ask you. Okay. Okay. Thank you. My second question is about the European Patent Office. As we know, today it is possible in Europe, in the European Union, to be more precisely, for trademarks to have a European trademark. That's a good point because in terms of competitiveness of a company which is located in the EU market, it's good. But still, for the patents, we do not have this possibility. Just imagine, in the United States, you have a very wide market, so if you have a patent applied there, you have some competitiveness advantages. Now, as you have shown us, we have to add additional costs for each country where we have to protect the patent in the European Union. Do you think, and I'm asking all the colleagues here, that in the near future we'll come up with a solution that patenting?
It's on the way. It's called unitary patent.
Somebody told me that would be in this year, but
Next year,
next year. Okay.
presumably, and it will be all the EU countries except Italy and Spain.
Why?
They didn't agree to join the system.
Okay. So this means we will have the possibility just to apply to the EPO and
Right.
we'll have protection in all this.
This is the objective.
Yeah, that's I think will be a good issue. Okay. Thank you.
Any other question? Please don't be shy.
So you mentioned the advantage of filing first in Romania in order to gain some time for priority before applying abroad. What about the possibility of differences between the what you file in Romania and what you file, let's say, in the United States. Because I guess that a patent application in the United States has to be quite elaborated, whereas the OSIM, I guess, would accept applications of, let's say, lesser quality. So can you file first at OSIM an application of lesser quality and then, I don't know, spend some time to build up and invest into good quality application for the United States and still be able to get priority on the first OSIM application, even there might be some differences of text between the two applications?
Your question is excellent. First, I would respond by saying that the quality of the applications with OSIM is not less than the quality of applications with US Patent Office. It's only that the law is different. There are sufficient differences between the law in Romania and the law in the US. The law in Romania is harmonized with the European Patent Convention, but the law in the US is different. So, and this being said, it depends on how much view and money in the pocket you have. Because if you are here before filing the first one, and you go to the attorney and you say, I would like to file in the US. Now, a good attorney will have to think how to draft the application in such a way to meet the very basic requirements of an application with, say, OSIM or the European Patent Office, and keep in mind some of the basic requirements of the US one. Only the basic, because a Romanian attorney is not supposed to know in detail the US legislation. Now, when you file the first one with OSIM and then you go, say, directly to US, then in US you will have to hire a US attorney. And that US attorney will respond to the numerous office actions raised by the US Patent Office. And let me tell you that the US Patent Office issues more office actions than the Romanian one and the European Patent Office both. So you will need an attorney in the US. And in case of doubt, you can consult with that attorney prior to the filing. In case of that, for example, in the fields where the differences are very important, for example, in the field of software, where the Americans are much more permissive than we are in Europe. I hope I answered your question.
Just in addition to what my colleague said, there are actually two issues. If I take your example of the first Romanian application followed by the US application claiming the Romanian priority, when the application is filed before the US PTO, the US application will be examined by the US PTO. And if there is a question regarding the date of priority, for instance, if the US PTO is identifying a prior art, or let's say a prior document to the filing of the US, but for which the publication was made between the Romanian application date and the US application date, then they might be very careful, review and compare both teaching, both documents. If there are some differences, if new subject matter has been added in the US application, and if this subject matter was not disclosed or present in the Romanian first application, then there might be some problems in that regard, yes.
I just like to come back a little bit to university patenting. You saw earlier that we try to implement some kind of ways of helping universities to patent at some lower costs, because again, patents at university are there to attract interest and not to for industrial reasons or reasons that industry may have. Do you think that it would be possible, and to which extent, to work together with universities in order to implement or propose some kind of ways where really the costs, the very early stage costs, are really kept down? But by down, I mean really low. At least say in the first year, because I saw a little bit the cost for a Romanian application. You have to, so it goes around 3,000 and something RON, yes. 3,000-4,000.
So I'll go back.
1,000 euro. 2,000 euro.
No, it's here. It's this
2,000.
this
It's
slide.
2,000. So okay. So this is for a Romanian patent application, which of course brings the advantage of having a search, and this may help. Of course, if we want to add on top of that even a provisional patent application that we would file in Europe or wherever, we would add 1,000 more. So we are about at 3,000 euros. So my question is, because I think universities here in order to foster this innovation policy, we have, and I think it would be important to create these opportunities. So, because it motivates the inventors also. It would motivate the universities, maybe bring also more and more cases to you as a patent attorney. Maybe not at the very early stage, but basically the strategy is to license those patent applications, so to create collaboration and partnerships. So some point in time that patent prosecution will be taken over by companies, and companies, basically they do not have problems with that because the patents are important to them. So do you think it makes sense, or would you agree, or to work with the ecosystem for some universities to explore ways of?
I think it is possible. I think it's possible, and I have two solutions in mind. One is that, as I said, one of the ways to minimize cost is to ensure a very good communication and very prompt response. If an attorney lowers his fees for a period of time, there's no problem. But this has to be something in exchange. This exchange is an excellent communication with the applicant or the inventor. That means the inventor is willing to do a lot of work and to respond quickly, because if you come to an attorney and you want something urgent and you want very low fees, it's not possible. Low fees goes with more time, not exaggerate time, and excellent communication and very good communication. So it is possible. It is possible, and it's possible not only this one, but it's possible also to work a budget. That means the applicant comes and says, "This is my budget for this year. Let's see what we can do within this budget." So this can be done. Of course, this does not apply to official fees, because official fees. However, some of the stages, some of the procedures can be also selected depending on the budget, because when the application is filed, there are several possibilities to request accelerated examination. It's not the case. To request first research report and then publication, so that there are some selections to be made. Depending on the moment of them, the fees have to be paid at that moment. So the working of the budget refers also to the official fees, not to the amount, because that is not decided by us, but playing with the moment of the payment. This can be done. So this is one solution that it is possible, at least at the level of our firm. The other solution is to do something in a more centralized way, because apart from my capacity of patent attorney and partner of Cabinet Oproiu, I am the current president of Romanian Chamber of Patent Attorneys. And being the president of Romanian Chamber of Patent Attorneys, I can do things in this capacity. For example, for including discussions with the patent office. Let's see if we can convince them to lower the fees, say for a period of time, or search fees, or if this is done in an institutional way, following a written request from the universities, it's an attempt. It's not up to me to decide, but if we can do it. And in this way, more universities can profit irrespective of the attorney that they select, because I can imagine that each university has the right to select the attorneys. Now, if something general applies for all of them, it's not important later on what attorney they select.
Yeah, I think your proposal there really makes sense and it's very helpful.
Okay.
So I think maybe just to add something, this implies also, as you mentioned, that on the side of the universities, there should be some programs or entities, I don't know if it's a TTO or whatever, but that create that awareness and helps in these early stages of patent preparation, in the description of the invention and these steps, so that the interactions with you are somehow minimized, of course, because
yes.
For that, I think that there should be also an effort on that side to be aware of what can be done to go to the point where I can file easier a patent application. With time, I think it will go through.
I would like to answer to your last interaction. My name is Alina Ciura. I'm representing OSCE. So, regarding our fees, I should say we are granting some kind of subvention, because for institutions financed by the state, as even the university here in Cluj is, we granted 80% reduction. So filing a patent application, even with examination fee, the first three, let's say, important major stages, the fees are reduced at even a 10% of the figure presented in your slide. This kind of provision applies also for the research contracts. So for the projects financed by public funds. So I think it's a major encouragement to innovation coming from university and public funded institutions. As far the awareness actions taken by the office, there were several European funded projects. We are going in some kind of caravan, if you like. We had excellent materials prepared by Academy, EPO Academy, patent teaching kit. There are basics elements, but we share it. The materials are public, are on our site. So, as far as our mission in this respect, I think we've done, and we are continuing to do things in this area. Thank you.
Thank you. This is great support.
Yeah, I confirm this is true. So for our university, for example, since we had this facility from OSIM, was an exponential increase of patent applications. So that is really working, and I think there are since 4 or 5 years, 5 years about this, since we have these incentives, and we thanks for OSIM for these initiatives and for the government. I have another question, because you mentioned about you practice this rule of thumb of 25% from profit when there are some difficulties in estimating the market value for the patent. I'm a bit concerned about this, even it is common practice since many years, because many times even with this profit you can play a lot and depends very much of many other issues. My question is how, in percentage, of course, approximately, how many cases, let's say, did you meet in the last, let's say, 5 years applying this rule of thumb in your university?
Yeah, well, what happens actually, this rule of thumb, 25%, there are a number of papers on that, so you certainly know. The nice thing of that is that those papers provide you with the information about royalty percentages per sector, in the bio sector, in IT, or whatever, consumer market, etc. So what we use is basically the royalty rate which is calculated. Actually these 25 rules help to build the benchmarks. So everybody, the university and the company know, okay, we will be in that range. Of course, you have to negotiate a little bit, but this is why also we mainly used, we use royalties instead of assignment of patents for an amount of money, and that's it, because it's difficult to calculate and it's more frustrating. Royalties is, okay, if there are a lot of sales, we get the royalty, it's fine. If we are not selling so much, there will be a lower royalty. So it's much easier to work with royalties. Now, there are cases, not so many, even cases where startups are licensed, and 1-2 years later, the VCs around ask, okay, but now tell me how much for this patent. I want to be owner of the patent. So, if not, I'm not investing round big for this. So since we try to do the best for the technology, so we would certainly not refuse to work with the VCs and the company in that direction. So in those cases, of course, you can calculate, so using these 25% rules or whatever the profits, and add over, I don't know, 10, 15, 20 years is the lifetime of the patent, basically. But usually when we license, it's already 3, 4, 5 years later after the priority date. So if you sum that up for 10, 12, or 15 years, you reach an amount, a certain amount. Usually it's many times around a couple of 100,000 euros. And but again, these are many times blue sky numbers. So really, I would say the less frustrating strategy is to work with royalties.
Yeah, and one question, because licensing is one practice, but what is important in a patent, we usually protect some issues, maybe architecture or something else, but then when you sell the license, the company will have to adapt the patent to the commercial product. And this is the technology transfer process. And my question is about the practice of your university in supporting the company to make this adaptation of the patent to the commercial solution.
Yes, of course, we can do that, provided the companies pays the costs for what we would have to do. So again, we have, I presented briefly this accelerator. This is early stage, so there is no transfer at that stage. But a company may come and say, well, it's interesting, your invention is great, but I have this and these applications. I need to know really better if I can apply your invention to application A and B. Okay, so let's try to do it, but this will cost some money, of course. So first scenario is the company sponsors that. Second scenario is a kind of matching funds with an option to acquire a license at some conditions at the same time. But your point is extremely important, and it's really in that gap that is crucial for technology to be transferred successfully.
Okay, we're coming up to the end of the session. I want to make two closing remarks. First of all, I think there might have been a little confusion. I think that this rule of thumb Professor Brad mentioned, this is for estimating before concluding the arrangement, not a contractual clause. So it's not a question of calculating it as because of course profit, it can be made anything. It's just a question of getting an estimate like this before starting the negotiation. And then you can name it anything. You can say, okay, we want 1 million. The guy says, no, 1 million is too much. How about 50,000? Oh, okay. You know, so
just that example with 2,000 euros the options for, okay.
Yeah, so, okay, so that was the first thing. And the second one is, I think that the conclusion that I would draw from all of this discussion and the question is that kind of brings it all together, is this is a full-time job. Okay, this is a full-time job for maybe several people, but at least for one person. And there are people representing the university here, and I'm very glad to have you here. And I think I would really ask you, I would beg you to transmit this message to the decision-making bodies of the university and of other institutions as well, all the institutions that are represented here, that you need to have at least one person fully dedicated to doing this, because otherwise it's impossible. You see the complexity of this problem. It's way too complex for somebody to handle in 20%, 30% of their time. It's way too much to do, way too many stakeholders, deadlines, documents, communications, everything. You have, and experience that has to build up over time. So this has to be one person that is designated. Without this, the institution will not be able to pass that step into efficiency. You know, so if the one conclusion comes out of this event, that there needs to be a commitment of having dedicated human resources, at least one person full-time worrying and talking to inventors, talking to patent attorneys, talking to all these people, to sources of funding, looking for industrial partners full-time. This would have been a great result of this event. So thank you very much for coming, and you will find the videos, recorded presentations on YouTube very shortly. I hope hopefully next week, and you can review them. We are waiting for any further questions, recommendations, proposals. So we are at your disposal for helping with what we can do to push technology transfer forward in the Technical University and in all the universities in Cluj, which I think are very promising. So thank you very much. Have a good day.